The exclusive contract dispute between idol group NewJeans and its agency ADOR is leading to a full-scale legal battle. While the members of NewJeans declared contract termination against their agency ADOR, the court defined this as a special case and announced a cautious judgment. According to the news from reporter Young Dae-hoon, published on the World Daily Portal, on the morning of April 3, the 41st Civil Agreement Division of the Seoul Central District Court, presiding Judge Jung Ho-il, held the first oral argument date for the lawsuit filed by ADOR against the members of NewJeans to confirm the validity of their exclusive contracts. On this day, only the legal representatives of the plaintiff ADOR and the defendant NewJeans were present. Unlike the hearing on the provisional injunction to preserve the agency's status and prohibit the conclusion of advertising contracts, etc., held on the 7th of last month, NewJeans members did not appear. The trial that day began with exploring the possibility of mediation before the full-scale battle. ADOR stated, "We hope to reach an agreement, but NewJeans drew the line, saying, considering the psychological state of the defendants, we cannot think of an agreement at this time." The positions of both sides were sharply divided. ADOR emphasized, the defendants claim that they cannot work without former CEO Min Hee-jin, but this is not true. The lawyer for ADOR stated, "We acknowledge Min Hee-jin's contributions, but the claim that NewJeans cannot exist without her is an exaggeration, and NewJeans has already successfully completed a Hong Kong concert without Min Hee-jin." He added, ADOR, an affiliate of HYBE, is the industry's top agency and has the ability to secure a replacement producer. In response, NewJeans argued that the core reasons for the contract termination were not simply the absence of a producer, but rather lack of communication and breakdown of trust. The lawyer for NewJeans argued, although ADOR had about 6 to 7 months to come up with an alternative, it failed to do so, and as the new management changed to a system that receives instructions from HYBE, ADOR became a completely different entity from the one the defendants trusted in the past. ADOR maintained its position regarding the resignation of former CEO Min Hee-jin, saying, it was not a dismissal, but a voluntary resignation. Even after stepping down from the CEO position, Min Hee-jin was offered to produce, but she refused on her own, saying, "I won't work unless I'm the CEO." After hearing the arguments of both sides, the court stated, there have been cases where idols have demanded the termination of their contracts without receiving a single settlement, but this request for termination on the grounds of broken trust is unusual, and since the concept of a broken trust relationship itself is abstract, we will approach it carefully from a legal perspective. Previously, on March 21, the court accepted ADOR's request for an injunction to preserve the agency's status and prohibit the signing of advertising contracts, etc. Accordingly, NewJeans cannot engage in independent activities without ADOR's consent until the main ruling. NewJeans filed an objection immediately after the injunction decision, and declared a halt to activities on stage in Hong Kong 2 days later. The hearing on NewJeans' objection to the injunction is scheduled for the 9th, and the second oral argument date for the exclusive contract lawsuit has been set for June 5. According to the news from reporter Jang Woo-jong, published on Chosunbiz Portal on April 4, the day after the first oral argument date for the lawsuit filed by ADOR against the members of NewJeans to confirm the validity of their exclusive contracts, some parents of NewJeans are found to be opposing this dispute. This is the first time that differences of opinion have been confirmed between the parents. According to industry sources on the 4th, at the first hearing of the confirmation of validity of exclusive contract held at the 41st Civil Agreement Division of the Seoul Central District Court on the 3rd, the presiding judge confirmed to the defendant NewJeans, it's about defendant 4, and is this a statement that the family court has made a decision on exercising parental rights and has ratified all the litigation actions up to now? Currently, among the members of NewJeans, there are 2 minors, Hyun and Haran. It is interpreted that there was a disagreement between the parents of one of them regarding the exercise of parental rights for the exclusive contract termination lawsuit, and that they even went to trial in the family court to resolve this issue. A similar statement was made at the injunction to preserve the agency's status held at the 50th Civil Agreement Division of the Seoul Central District Court on March 7. At that time, the injunction court said before the questioning, we need to sort out the proxy issue. First, there is a flaw in the current proxy rights. Minors are jointly represented by their parents, and the fact that there is a flaw in the proxy rights means that the parents do not agree on the termination of the exclusive contract, and this issue needs to be resolved. At that time, the attorney from Sejong law firm representing NewJeans responded, there was a hearing in the family court yesterday, and there will be a conclusion at least next week, and I think there will be no special issues if we submit it once the conclusion is reached. The court stated, according to the Civil Procedure Act, it is supposed to be corrected, but the defect has not been corrected to date. This means that the parents of the minor members do not have a consensus on the matter, and thus they are unable to jointly exercise their parental rights in the lawsuit to terminate the exclusive contract. However, judging from the fact that the court stated on the 3rd that the decision to exercise parental rights has been made and the lawsuit has been approved so far, it can be inferred that the parent who opposed the lawsuit was restricted and the lawsuit was conducted according to the opinion of the parent who supported it. According to the news from reporter Park Dae-young, published on Money Today Portal on April 4, Group NewJeans deleted traces related to the team name NJZ, which they had put forward as they were to work independently from their agency ADOR, from their SNS, social media, accounts. NewJeans members Minji, Hani, Daniel, Haran, and Hyan changed their SNS account names from NJZ Official to MHDHH Friends. MHDHH seems to be a combination of the first letters of Minji, Hani, Daniel, Haran, and Hyan's English initials. All of the posts they had uploaded before changing their account names were deleted. This appears to be a measure taken in response to the court's decision to ban independent activities. The SNS account that reveals the official position of NewJeans parents was changed from NJZPR to MHDHHPR. After deleting the previous posts, a parent statement was posted. According to the news from reporter Kang Juil, published on Sports Trends portal on April 4, the NewJeans parents posted on SNS, "It is completely untrue that there is a split between the members' parents, and all 5 members have a firm stance that they cannot return to HYB. The parents also fully respect their children's wishes and continue to support them." They said, "The members meet often despite the difficult times and maintain an unchanging friendship, and the parents also communicate more regularly and maintain a strong relationship due to the difficulties, so it is embarrassing and regrettable to see groundless rumors about family divisions and member departures being made into articles." Meanwhile, the parents of NewJeans said about the rumors related to Haran, "The related flyers are completely different from the facts, and all speculations about the family history are not true. It was the other members who respected the minor child's wishes and proceeded with the parental rights adjustment, and this family also has a firm will of the child and the mother, so please refrain from speculating." They also said, "The parental rights issue is one person's family history, and we hope that it will not be maliciously used by linking it to the legal dispute with ADOR, and ADOR and HYB, whose management has changed, have never shown us trust, and this has not changed even once to this day.